bem-vindos todas e todos ao nosso terceiro dia de discussão. Gostaria de passar a palavra para Natália Neres, para esse primeiro painel de hoje, Interseccionalidade, Instituições e Direitos.
Bom dia a todas, todos. Nós vamos dar início, né, à terceira sessão, cujo tema vai ser Direitos das Mulheres, Sistema de Justiça e Políticas Públicas. Antes de mais nada, eu gostaria de agradecer pela oportunidade de estar nesse papel, né, de mediação. Para mim já foi muito bom participar do evento com tantas especialistas e com tantas falas que me fizeram crescer muitíssimo e aprender muito, e estar nessa posição, para mim, acho que é um privilégio. Eu agradeço a coordenação e principalmente a Marta, que é minha orientadora. O título desse painel é Interseccionalidade, Instituições e Direitos. A gente vai fazer como a gente tem feito até aqui, 20 minutos para cada expositora, e depois a gente reserva um tempo para o debate. E eu vou seguir a ordem da programação, apresentando a primeira expositora, Laura Healy. Laura Healy é advogada, mestre e doutoranda em Direito. Sua pesquisa aborda a contribuição da diversidade de gênero para a litigância judicial em jurisdições de common law. Trabalhou em diversas organizações comunitárias e é assistente na John College, em Oxford. É editora do blog Oxford Human Rights Hub e ex-coordenadora do Oxford Pro Bono Público. O tema da fala da Laura será Situar-se nas intersecções, a identidade dos juízes importam? Laura, 20 minutos para a fala. Quando estiver faltando 5 minutos, eu retorno para você.
Thank you very much for that introduction, and thank you to the organisers for welcoming us here in Brazil and for all the hard work you've done to bring us here. I thank also the interpreters, particularly with this panel, as you have to struggle with 4 different English-speaking accents, so I hope that we don't cause you too much trouble. So I've decided to look at the topic of the conference today, which is multiple identities through law, by having a look at identities of those who sit as the interpreters of law, or in common law countries, the makers of law even. And so what I'm going to do is investigate how the identity of judges, and particularly the intersectional identity of these judges, might impact upon their role in the work that they do. And so judicial identities has become a growing area of study around the world. It's been an area of study in both common law jurisdictions, like South Africa, Australia, and the United Kingdom, which is where my research focuses. But also it's become relevant in civil law jurisdictions, where many researchers are refusing to accept that the judge is simply the mouthpiece of the law. And so I hope that what I say today might be relevant to those of you working in Brazil and working in the context of judicial activities in a civil law country. So I'd argue that this project of looking at judicial identities is both one of scholarly concern, but it's also turned into a form of activism and a desire of people to transform courts and to see equality happen in courts, not just in the work that the courts do, but in who is doing that work. And the reason for this is it's a response to an enduring homogeneity in many countries in the composition of courts. In common law jurisdictions in particular, we see that the judiciary is characterised by certain identity characteristics, namely being a man, being middle class, and being white. This is problematic, particularly in superior appellate courts, where we see the greatest amount of homogeneity, because these courts are positions of power and prestige, and they're often exclusionary to women and ethnic minority groups. So I'll start by having a look at a few statistics, which I'm sure are familiar to many of you in the room. But this graph here shows how it really is a shared project. There are no courts in the world where we see the majority of members being 50% women. The problem is more stark in certain jurisdictions. As we can see, Latin America and the Caribbean are doing better than some other jurisdictions, such as Europe, but still, we're not getting over 50% as a whole. But the problem becomes more pertinent when we start thinking about the senior judiciary, so the final appellate courts. So this graph up here shows Brazilian statistics, which see that only 18% of the positions in superior courts in Brazil are held by women. And as you all know, of your constitutional court, of all the 11 positions there, only 2 of them are held by women. This is a similar picture to what we see elsewhere in the world. So while in the UK, 23.5% of all judicial post holders in the United Kingdom are women, only 17.3% of those posts are held on superior courts. However, what we see in judicial identity studies has been a tendency to look at the identity of judges on a single axis basis. So the statistics that I have put up are looking at the gender of the judge. We also do have a limited amount of data collection that looks at the race of the judge or the ethnic minority status of the judge. But rarely do we see statistics being collected that look at these identity characteristics in intersection with each other. And this is where we see the problem becoming a lot worse. So what the trends show is that the more that you differ from the status quo traditional idea of what the judge is, being a white, middle-class man, the less likely you are to hold one of these positions of judicial power. For example, in the United Kingdom, there are 161 posts in the senior appellate judiciary. Only one of these positions, 1 out of 161, is held by someone who is a black or ethnic minority, and that person is not a woman. We see in the High Court of Australia that 3 out of the 7 positions are held by women, but all 7 of these judges are white Anglo people. South Africa also shows this similar trend, and I'm sure that Elsha will focus more on the South African statistics. But we've seen huge amounts of transformation in terms of racial transformation of the judiciary since democracy. But we have not seen the same amount of transformation in terms of gender. For example, the Constitutional Court at democracy had 2 women judges sitting on the bench, and there are still, 20 years later, only 2 women sitting on that bench. So I ask, why does this all matter? Well, I say it's a question of power, predominantly. It says something about who holds power, who is seen as legitimately holding power in our societies, who is elevated to these positions of power. It's also a question of fairness, and fairness to women in the legal profession. So in many of these jurisdictions, we've seen for many years women entering the legal profession in the same rate as their male components, and the same trend with black and ethnic minority groups. However, they are not rising up the ranks at the same rate as their male counterparts. So it's an employment equity question. A lot of people also in this area talk about the confidence in the courts and institutional legitimacy questions. How can we have faith in these institutions if they are so unreflective of the societies that they serve? But the question that I'm going to look at today is about the quality of justice that these courts can afford, and whether the identities of judges somehow impacts upon the quality of justice. So this research today, this paper today looks at research that I've been doing as part of my doctoral studies. And I'm going to draw on empirical data that I collected in 2012 and 2013, where I interviewed 30 judges from senior appellate courts in South Africa, Australia, and the United Kingdom. The purpose of my interviews here was to investigate whether senior appellate court judges perceive their own gendered life experiences and the gendered life experiences of their colleagues as impacting on the collegiate decision-making process. I embarked upon this research on a single axis premise, looking at women as the indicator of investigation. However, my research has shown that often it's not gender alone that is being the determinative factor on how the impact is being made, but rather gender in combination with another identity factor. So the findings of my research, to summarise at the outset, in case you can't keep track or feel like you want to doze off before the end of my presentation, is first that identity does matter, that judging is not purely a subjective endeavour. This research has been done in a common law context, But I would argue, and after discussing with civil law colleagues, that this application and this finding could also have resonance in civil law jurisdictions. The second thing it will demonstrate is that there is a danger in putting too much emphasis on identity and too much emphasis on identity grounds in order to determine or prescribe a way that judges will behave. So saying that a woman will decide in a certain way simply because she is a woman is a dangerous argument to follow through. And third, it will highlight that experience that is intersectional is often the most enlightening and most impacting upon courts. And because what it does is opens up the consciousness of the courts in a way that was previously not available to them until they had that person with those diverse experiences come in and share those experiences with them. And so I'll show at the end of my presentation that these have been the most enriching for judicial discussions. So this research is based on feminist standpoint theory, which I'll just discuss very quickly. Feminist standpoint theory is derived from Marxist theory, and it shows that there is an epistemological value in perspective shaped by life experience. By epistemological value, I mean that it's a valuable knowledge, that judges bring to judging, and that knowledge is derived from their experience in the world. First, it looks at perspectives that are shaped by experiences. Second, it realises that our place in the world, or where we're situated, such as our gender, will impact upon our experiences. But third, it requires not just that we live life as a woman, but that we reflect on our life as a woman, or we reflect on our life from our particular standpoint in order to understand how we might be different from other people, in order to give us that perspective. So similar to how comparativist lawyers work, our standpoint can give us new perspectives and allow us to see the strange in the familiar and to critically challenge received knowledge. What's important to standpoint theory is that it operates within a context of received knowledge, like the law. It's not saying that judges can go out and decide how they want on a whim, but rather that they will operate within formalised traditional structures, but perhaps bring new perspectives in order to critically engage or interrogate what has previously been received knowledge. So I can only show a few of my findings today. But the first one is the most important and perhaps the most basic, that the identity of the judge really does matter. Many of my interviewees accepted this. So this judge here, I might take this out so I can read off them. So this judge here was talking about social awareness and saying that social awareness is intrinsic to the value and nature of the judicial project. And you can't simply rule by grammar or technical analysis, by abstract reasoning. Judging isn't simply applying social awareness to problems. So this is where I bring in standpoint theory. It's not about a judge just deciding how they feel, but rather social awareness feeds into this process. It's one of the central elements of the judging process, but it doesn't occupy the whole space. So it's neither an add-on to a purely technical thing, nor is it a basic canvas in itself, which you can trace a few judicial lines. This judge here, when I asked them how much I thought that common sense applied in the role they did as a judge, actually laughed at me. And then I went on to say, you can't just laugh at me. And they said, well, it's elemental, it's the start of everything. It's possibly the first and even the last post. And I said, okay, and in what way? Some people would say that social awareness or common sense has nothing to do with the role of the judge, and that's just applying law and deciding cases. This judge thought that that was absolute complete nonsense. So we see from these quotes that the judges do think that their own personal perceptions of the world do impact upon the way they judge. This judge here, to the extent that the value occupies a central and often commanding place in the judicial function, social awareness becomes imperative. In a case where the very nature of the constitutional project is transformatory, and without social awareness, transformation becomes meaningless, then you are just judging with abstract concepts and ideas. So in this way, this judge from South Africa was saying that social awareness and perceptions of the society that they lived in was important to give life to the law, to make it meaningful in the people's lives and who they were judging on. this second quote is very important because it shows that the practice of self-awareness in judging and the way that different perspectives can challenge each other in the judging process. So this judge was saying, you know, you might think that X is common sense, and then you find a colleague has grown up in a different environment or has a different life experience, and it's not common sense. It might be an outright lie that's certainly not accepted as the norm. But so we see that, yes, identity does matter, but will it be determinative? And this is one of the problems that we get in this area of study, is a fear of essentialism. And so this quote here, and I'm going to go a little bit faster because I've only got about 5 minutes to go, is saying that identity essentialism is dangerous. We can't just assume that women will decide differently from a man. And this example that I give here is showing in the context of rape cases how this can be particularly problematic. So the first quote, I'm asking a male judge about women having different approaches in certain cases, and this judge thought that women had different approaches in rape cases. And I said, well, why? Why is that? Is it because they have different expertise in that area or they have a professional history in that area? And he said, no, I think it's just human nature. I think that females are able to, you know, record the feelings and the trauma that a rape victim would have gone through, you know, better than we do as males. However, the second quote here is from a female judge, and she said that she often feels vilified by lawyers' groups, and particularly women's groups, in some sentencing that she's given in rape cases, because she hasn't been harsh enough on the perpetrator. And she feels that there is this expectation that as a woman she will decide and act in a particular way in rape cases simply because she is a woman. There is also another problem with determinism and getting some kind of authority because of your identity. And this is where judges might feel that they represent a particular constituent because of their identity. In this case, this judge said that, a black African judge said, I sit in the court as a black judge, and there are instances where African law, that I'm in much better position than my white counterparts. I can understand the nuances. I believe the perspective of living African law. I didn't read it, I am living through it. I know what I mean. But this idea of authority that is demanded because you have a particular identity is also problematic. It doesn't allow you to open yourself up to other perspectives and to be challenged, which is what we need, I think, in order to truly engage with different identities on the bench. So there's a real importance of self-awareness, and that you need to be open to know who is different and who is similar to you. To learn your blind spots and understand that your own life experiences can enrich your judging, but they are only your own life experiences, and therefore they might need to be challenged by those around you. And the final part of my research, which has been really interesting, has shown that it's often not just gender that has been the determinative factor in why people, in how experiences impact upon judging and how identity impacts upon judging. So this is a quote, and this is a very nice quote from a woman judge, a black woman judge who had a rural upbringing in South Africa. And she said, she was talking about how she felt that her identity, through being a woman, living in a racialized context, and living in a disadvantaged socioeconomic context for the majority of her life, had all come together to impact upon her perceptions of the world and the way that she then performs her functions as a judge. So she says, people, for instance, who have not lived in rural areas don't know how hard it is to have a bucket of water in your home. And if you come from that background and you sometimes go home and experience it firsthand, it's very difficult for you to explain to a person who does not have that advantage, how difficult things are. And I know because sometimes when I am back in the suburbs, I tend to take certain things for granted until I go back home where I grew up. And I realise how important it is to have a toilet that can flush. She also talks in the second quotation about growing up as a woman in this ruralised context and saying that you grow up with the girls, you're a woman yourself, and you listen to your friends and how they relate to things that have happened to them. You know how scared you are sometimes of being hijacked, for instance. I'm a woman. People would lock their houses because they don't want their possessions taken. I would lock my house because I'm scared of being raped. So because I'm a woman, I would think of that. So she felt that these kind of perceptions and this kind of understanding of the world impacted greatly on the way that then she approached her cases that came before her. This final quotation here also shows that it's not just the individual judge that benefits in the decision-making process from this intersectional experience, but also the judges who have not had this experience, particularly in collegiate courts where the judges talk to each other when they're arriving at their decisions. So this quotation here was from one of the, status quo white middle-class male men who was talking to me about how grateful he was to have the experience to talk to one of his black male colleagues in this context who had also grown up in a ruralised and disadvantaged socioeconomic context. And so he talked about the impact that the interacting with his colleague had upon his own judging. And he said, one of the earliest black judges was a local, so I knew him as an attorney and so on. But for the first time when he came to the bench, you would know that eviction cases were one of the first things that the Constitutional Court had an impact on. And then we were sitting in the tea room and he was saying, well, you must remember I come from a house with one room, and that was our family, one room. And when we experienced eviction under apartheid era, it had a huge emotional impact. I think for myself and for the more older conservative white judges that was an eye-opener. We're used to living in nice, comfortable houses, and suddenly, this is a colleague of ours who now tells us that his house was one bedroom. So this shows the power of intersectional identities on the bench, not just for the individual judge who has those experiences themselves, but also for sharing and educating their colleagues who may not have had the advantage of a rich life experience in the same way that their colleagues might have. So just to conclude very briefly, I want to say that identity markers are very important in judging. And so yes, we are still campaigning for more women judges. We think it's a travesty that 17% of the UK Superior Court are women, that we only have one woman and only have ever had one woman on the Constitutional Court. It is not fair that only 2 out of the 11 in the Brazilian Constitutional Court are women. But we need to be careful, and we need to use single-axis identity markers as the starting point, and we must always remember the intersectional aspect of it. So we need to look for diverse experiences and not just stop at identity markers. Thank you.